morning and welcome to an oral argument session for the 5th District Court of Appeal. We have a one case set here today at 9 o'clock. It's the Rashad Muhammad case versus the state of Florida. My name is Judge Rand Wallace. I'll be presiding over the proceedings here today. With me from our court joining us on these oral arguments is Judge Eric Eisnagel from Seminole County and Judge Dan Traver from Orange County. Counsel, I will give you 20 minutes per side for oral argument today. I'm going to assume the appellant would like 5 minutes of rebuttal time unless you inform us differently. Anyways, I will just allow the appellant to begin when you're ready. And I think that's Mrs. Walsh, is that correct?
Yes, Judge. Good morning.
Okay,
May it please the court, opposing counsel, Michelle Walsh on behalf of Mr. Muhammad. The conviction in this case can't stand because no instruction as to excusable and justifiable homicide was read with regard to the main charge of conviction, which is attempted second-degree murder. This court has held in Blandon versus State that it's fundamental error to not read that instruction in murder and manslaughter trials. And that's the case, even if there's no basis in fact for the charge, according to Blandon versus State. The state conceded in its answer brief that pursuant to Smith versus State, decision by this court, that the error is per se reversible. And the absence of an objection by defense counsel does not waive the error. In this particular case, the court read the attempted second-degree murder instruction 6.4, which has a warning that in the absence of an express concession, you have to read 6.1, which defines excusable and justifiable homicide. Even though the defendant doesn't have to demonstrate that there was a basis in fact for the charge, it was his primary defense at trial. It was the only defense presented in this case. Defense counsel argued accidental discharge. The state rebutted that argument in their closing argument. They argued, does that sound like the action of a reasonable person if they're claiming accidental discharge? And the defense was based on the defendant's statement to police, which was exculpatory. In his statement to police, which was introduced at trial, he testified that he never pointed the gun at Alicia Klein, that he pointed it at no one, that he was attempting to unload the gun when it was pushed backwards and fired. There was no other evidence supported the defense as well. There was no
Walsh, for clarification, was there, I believe the factual scenario, there was at least an allegation made that Miss Alicia and Miss Samantha may have made movements toward your client with the gun while he was cleaning or discharging the gun. Is that correct?
Yes.
Okay, thank you.
Miss Klein, Alicia Klein testified, actually she clarified on cross-examination that she pushed the gun up and away, and that is when the gun fired. All three persons that were present in the room at that time all coincide that the gun was fired at that moment only, when the gun was pushed away and up.
And was the angle of discharge of the gun consistent with your client's theory of defense in this case?
There was no testimony as to the flight path of the gun, and that's one of the issues that we've raised, that there was no expert testimony to justify the prosecutor's argument in closing that the defendant's claim that it was at a 45-degree angle was a lie. The prosecutor relied on pictures of a utility pole and the home, damage to the home, without there being any kind of height measurement. So it's illogical to conclude that two individual pictures of damage can lead to the jury to conclude as to a flight path. Additionally, the jury was unqualified to reach that decision, the same way that they can't compare handwriting samples and reach a decision without expert testimony. And in this case, there was no expert testimony. There was a crime scene technician who testified that the damage to the utility pole in the home was adjacent, and he couldn't go further than that. Without a reconstructionist or a ballistics expert, the First District has held that you can't have the jury conclude anything as to flight path. And precisely because the defendant's credibility was at the heart of this case, because his exculpatory statement was presented to the jury, that error in allowing the prosecutor to argue that in closing arguments is the state can't demonstrate that it had no effect on the verdict in this case. Going back to the first issue, this cases relied on by the state in their brief are inapposite. In Elliott and Franco, the instruction was read, whether it was read as on a lesser charge, the instruction as to the introduction to homicide instruction, whether it was read as to a lesser charge, or whether it was read on the main charge, the jury heard it somehow. In this case, they never heard it. And it's our position that the holding of Knight doesn't apply to this issue, because the holding of Knight is really hinges on the jury pardon doctrine. In this issue, we're claiming that the error lies in the main charge of conviction. So there's no danger, as Justice Kennedy described in his dissent in Haygood, of the jury reaching a lawless result or the defendant having a fundamental, a claim of fundamental error in the jury reaching a lawless result. So Knight really doesn't apply to this claim.
I mean, it would apply if there hadn't been an error in the instruction on the offense of conviction, correct?
It wouldn't apply to the claim that...
Well, in other words, your second issue is that there was error on the manslaughter instruction, which was the offense one removed from the offense of conviction.
That's
So
right.
for your second issue to succeed, first there'd have to be error in the offense of conviction, which I understand is your first issue. And then secondly, there'd have to be error in the manslaughter instruction, which I think is your second issue, correct?
Correct.
Okay.
Regarding the sufficiency of the evidence in this case as to Samantha Klein, our position is that there wasn't enough evidence to prove that the defendant harbored an intent to kill Samantha Klein, and that's how it was charged in the charging document. The jury, or rather the state, charged that the defendant harbored an attempt to kill Samantha Klein. The jury was instructed that they had to find that Samantha Klein was the subject of the defendant's intent to kill, and the jury found him guilty as charged in count 1. Yet the state really introduced no evidence that the defendant harbored any ill will towards Samantha Klein. This court held in Sandhouse versus State that normally in a second-degree murder, depraved mind requires some degree of enmity, and extreme recklessness is insufficient to fill in the gaps of ill will, hatred, or spite. And in this case, the evidence was that the defendant never pointed the gun at Samantha. I think the state argued in its supplemental brief on Knight that there was some testimony that the defendant had pointed the gun at them, but there was no such testimony at trial. It was very clear. Alicia said he had raised the gun at her. Samantha never testified that the gun was pointed at her at any time. There was no evidence of any enmity from the defendant to Samantha. He wasn't breaking up with Samantha. In his statement, he said he got along well with her. And after the gun went off, he went outside to try to calm her down. So there was really nothing in the record to reveal the degree of depraved mind necessary to find him guilty of attempting to kill Samantha Klein. And the jury was paying particular attention to that because they asked for clarification as to the definition of depraved mind. Additionally, it's our position that it was error to allow the state to argue transferred intent, because what happened was the jury was permitted to find the defendant guilty of an offense that wasn't charged in the indictment. And you can't transfer intent from an unintended victim to an intended victim, which is what they were essentially trying to do. There's nothing right now stopping the state from charging the defendant with the same exact factual pattern and just switching the name to Alicia Klein. So he's subjected to double jeopardy right now. It's a fundamental principle of due process that someone cannot be convicted of an uncharged crime. And attempting to kill one person versus attempting to kill another person are two completely separate crimes. And the identity of the victim is critical to each crime. Regarding issues 1 and 2 of our brief, we're going to be relying on our supplemental briefs. And I don't have anything else unless the court has any questions.
May it please the court? Have we got audio? Sound good?
Yes.
My name is Carmen Corrente. I'm with the Attorney General's office. And I'd like to start with the second-degree murder, general intent crime. There was ample evidence in this case. The jury never went any further than the second-degree murder. You can tell by the jury question, which was depraved mind, as counsel mentioned. They wanted to know more about that definition. They were also instructed on the voluntary manslaughter, and the instruction clearly let them know that negligent actions would not suffice for even manslaughter, because the instruction that was read, the attempted manslaughter was only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death.
Mr. Corrente,
Yes.
question.
Yes.
Why doesn't our case, Hall versus State, control this case?
Case are you talking, which case are you talking about?
Hall versus State?
I'm sorry, I had focused, I think what controls this case actually is your Melendez case, which came out last week. And that was going to be my argument. I wasn't going to rely on Hall.
If I could maybe bootstrap on Judge Wallace's question, we've got a line of case law, and opposing counsel referred to it, starting with Blandon v. State, which is 25 years old, that says that it's automatic reversible error not to deliver the introduction to homicide instruction, and it doesn't matter what the facts of the case are. Could you address that line of case law, please, and its applicability, if any, to this case?
Well, it's not applicable to this case because of the recent cases in Knight and Melendez. It's not any longer per se reversible error. That's what was held in both of those cases. So you have to look further to see whether or not fundamental error has occurred. And that's what those cases discussed. And it's not fundamental error to fail to read that. For instance, the exceptions back in that line of cases where if you waived it, or more recently, if you admitted or consented to the fact that you didn't raise that defense. The state's position in this case is that the defense really wasn't raised. The defense was not that I accidentally shot her. He never admitted putting his finger on the trigger. A gun does not go off if you slap the barrel. The finger had to be on the trigger in this case. He had to wave that gun in her face in order for her to be able to grab that barrel and move it away. There was animosity between them for the week before where they were she broke up with him. She said, don't come down. He came down from Ohio. She broke up with him. She wasn't going to eat dinner with him that he prepared. She wasn't going to get back with him. She had other people coming to help her move.
Counsel,
Yes.
His defense was that he never pointed the gun at her at all, correct?
Correct.
So what you seem to be relying on, the evidence in a light most favorable to the state, but I'm not sure that's the right standard here. If his defense was he never pointed the gun at her at all, then when we're looking at the evidence or the defense as he presented it, as the defendant presented it, then why wasn't the instruction on excusable and justifiable homicide appropriate here?
Well, he wouldn't have fit within the parameters, even if that instruction had been read. But to answer your question more directly, he couldn't, for the gun to be within reach of the victim, for her to be able to move it aside, it's pointed at her. His testimony.
Counsel, once again, you're assuming the facts in a light most favorable to the state. Isn't the question here, did the defendant present a defense consistent with excusable or justifiable homicide? His defense was he never pointed it at all. Now, I understand you take issue with that,
right?
That you don't find that credible, but that was nevertheless his defense, correct?
Correct.
And if the jury had believed that he never pointed it at anyone, and that in fact, he simply held it at a 45-degree angle to clear the gun, right?
Right.
And how was that not consistent with excusable and justifiable homicide instruction?
Well, the situation you would have is then with the justifiable and excusable homicide, you've got to be able to show the exercise of care, due care. And again, for him to be unloading the gun, not pointing it at them, but unloading the gun, a live weapon with a chamber loaded, and having it be able to go off so that it hits someone standing in front of him has got to be not even, it's not just merely negligent, it's intentional. The whole argument of the state during the entire closing, the first half of the closing, was that this was an intentional act. This was animosity between the two of them. And there is evidence to show evil, hatred, evil will and intent.
Counsel, I understand the state's view of the case. I do. And I understand all the arguments you're making, but make an argument that excusable and justifiable, the instruction for excusable and justifiable homicide, make an argument that was not necessary based solely upon the defendant's defense presented at trial. Don't point to any of the evidence that the state wants to point to. Point solely to the defendant's defense and tell us why that instruction was unnecessary.
With the defendant's defense, he had to still establish that he was negligent at the very least. That was not his testimony or his statement. His statement was that he did nothing. He had no finger on a trigger. He didn't point it at her. He didn't fire the gun. The gun went off.
Isn't there a difference in the instruction, counsel, between negligence and accident and misfortune? I mean, isn't the defendant's theory of the case that he was at Alicia's request disassembling the firearm?
Yes, he was.
The state's firearm expert said that there's two ways to do it. The way that he did it was not the recommended way because it could lead to accidental discharge. And then you've got the first paragraph of the excusable homicide definition relates directly to doing something lawful, but committed by accident and misfortune. How does that not apply?
Well, I mean, it is part of the instruction, and it would normally apply, except the defendant himself never stated that it was an accident. He never said, I shot him. I shot it by accident. I pulled the trigger. My finger slipped. He didn't do any of that. He just said, they came running at me, pushed the barrel, and the gun went off. And that's what he said. And is that an accidental discharge? Well, I mean, it was not argued that way. They had an instruction that attempted manslaughter instruction, I read you, but defense counsel did not even argue it. Didn't argue that this was negligence, didn't argue that it was justifiable. I don't think it would fit within that definition because you have the duty to use ordinary care.
So,
and
counsel,
even with his testimony, I don't think he used ordinary care. Because
counsel, the defendant holding the gun, attempting to clear it, and then the gun accidentally going off, whether his finger's on the trigger or not, that couldn't be an accident or misfortune.
It could be, yes. I mean, I understand, I agree. And if he had said that's what happened, if that was his testimony and the evidence presented and the argument presented, I just don't see that it was done in this case. There are a couple of lines. I mean, the word accident isn't even mentioned maybe twice in this trial. They don't call it an accident. They were trying to make sure he would be acquitted of all offenses, not just second-degree murder, not just manslaughter. They were playing a strategic game to try to say, the jury will find it's an accidental discharge. We don't have to go into an ordinary care analysis. We don't have to explain anything about the trajectory and what happened. We were going to get them to say it was simply not intentional, and not an act that qualified as manslaughter. I believe that's what the defense was arguing.
If the trial court had delivered the proper manslaughter instruction, would it have cued the trial courts to its omission of the introduction of homicide instruction? In other words,
Yes, I think
yeah.
so.
Okay.
I think so. I agree with that. I think that if it had been mentioned, but I also think the defense strategy involved that because they didn't argue it. Even though it was in the instruction without definition, they still didn't argue it. They didn't argue negligence. They didn't argue this was a merely negligent act. He's Army trained. He eats with his gun.
I don't
So
necessarily disagree with you, counsel, that they didn't argue negligence, but it seems to me like you're using accident and negligence synonymously, and I'm not sure that that's true.
I would agree with that. I agree. You have to show at least something to claim the accidental discharge. You have to explain how that happened, I think, and you have to either be negligent or it has to be some fault with the weapon, is what I would say.
But I mean, does Mr. Muhammad necessarily have to be negligent in how he's disassembling the shotgun if it accidentally goes off?
No.
For example, because somebody grabs the barrel.
No, that is a possible scenario, but at the same time, he's also, I mean, as far as the scientific evidence, the gun is not pointed where he claims. And I understand Judge Eisenhower, that's part of the evidence, but it's the jury who starts with the highest crime charged, looks at those facts, and this jury went no further. They asked to see the gun. They asked for more definition on depraved mind. And then they asked to be played, the defendant's statement to be played back. They listened to all of that. They didn't come down to negligence or anything else. They came back with less than an hour with a verdict, conviction across the murder counts.
Mr. Corrente, to kind of piggyback on Judge Traver's question, in a scenario where arguably it's an accidental discharge, is accidental synonymous with excusable?
With what? Excuse me?
Is accidental synonymous with excusable?
No, it's not. It doesn't, because under the statute, you have your actions, the intent of the act, or the act you're committing, how it's done. You can say it went off by accident, but if you're waving a loaded gun in front of somebody and have your hand on the trigger, then yeah, it may have gone off and you may not have meant that, but that's not excusable.
But if you're not waving a gun, but you're trying to clear the weapon and you don't have your finger on the trigger, it may be close by, but not on the trigger, and someone lunges at the gun and pushes the gun away, is that excusable?
Under the facts of this case, no, but generally with just those facts, yes, that would be excusable. And all you have to do is say that's what happened. And I think you would have no trouble showing in court, this was an accident. This is what happened. My finger slipped. I hit the trigger. It went off only because she hit it. They both admit they hit the gun.
Counsel, can I go back to your first answer? And it was about the line of case law that started 25 years ago with Blandon. Is it your contention that Knight and Melendez should cause us to recede from that line of case law? And if so, why?
No, not to recede from that line of case law, but we're talking about here the manslaughter, and we're talking about the facts in this case and how Melendez stated that it's no longer per se reversible error.
Well, simply, Blandon discusses the offense of conviction. So the jury pardon doctrine, which was abolished by Knight and which we recognized in Melendez, relates to an offense one removed when there's no error in the offense of conviction, correct?
Correct.
And I'm wondering if we've got 25 years of cases that say that it's per se reversible error to not deliver that instruction, and that instruction applies to the offense of conviction, how we don't stop right there.
Well, Melendez, my memory of Melendez, and maybe I've read it wrong, but my memory in there was that the court stated that justifiable and excusable homicide was not read for the attempted, was a second-degree murder, yet that was not enough. That was not error. It was not fundamental error.
So your argument is basically the idea that that line of case law might not apply if no evidence supports the reading of the instruction.
If no evidence supports it, if the jury is properly instructed on the elements of the crime itself that they convicted him of.
Yeah, I mean, one reading potentially of that Blandon line of cases is that introduction to homicide instruction is part of the instruction relating to the offense of conviction, correct?
Correct.
Okay, thank you.
Yes. I don't know if the court wants me to address any of the remaining issues, but it is the state's position that the jury had clearly enough evidence. They believed that he acted with intent and with malicious intent because of the facts of this case. He did not buy the fact that it would be manslaughter, that there could be negligence or any of those issues. None of this required or amounts to fundamental error or what happened below, because there is enough evidence to show attempted second-degree murder. And we would ask you to affirm. Thank you.
Thank you, counsel. And Ms. Walsh, you've got a little less than 11 minutes to go. So
I'll be brief, Judge.
Counsel, can I ask you before you start, if we agree with you on the first issue, do we need to reach any of the others?
If the court agrees with me on the first issue, it doesn't address the other two charges of conviction, and we've raised a claim of error regarding the improper closing argument, which would affect the other two convictions as well.
Okay.
So I would say that at least that issue would have to be addressed. Unless the jury has an instruction on a defense, there's no avenue for the defendant to have that defense properly considered. You don't have to say the words, "I accidentally shot the firearm," for the defense to apply. Counsel did argue accidental discharge, and the state rebutted it, specifically referring to an accidental discharge. And the state's own witness testified that the manner in which the defendant was unloading the gun can result in an accidental discharge. So there was ample evidence to support the instruction. I disagree with counsel that Knight reverses Blandon somehow. Knight is limited to its own holding, which really deals with lesser included charges. And we don't have that in this case. In this case, there was never, the introduction to attempted homicide was never read. So the terms justifiable or excusable homicide were never defined. That never happened. And the defendant is entitled to relief on that ground alone. Unless the court has any other questions, I don't have anything else.
I don't think we have any other questions. So with that, we are in recess. Thank you, counsel, for your arguments.
Thank you, Judge.
Yeah.
Bye-bye.